I know there are a lot of cases going on right now, and it's kind of hard to keep track. I'm going to talk today about a case that isn't getting a lot of attention, and it's actually pretty important because it's about the right to vote. A few months ago, the League of United Latin American Citizens, or LULAC for short, sued the Executive Office of the President over an executive order that very much changes the historical boundaries of federal control over state voting requirements. And I'm going to be making more videos about voting law in the future, but for today, I want you to be aware that the case exists, and I'm going to break down a procedural motion in that case that the plaintiffs made yesterday, July 11th, because it's something you've almost certainly heard of before, but I want to use some examples to clarify what it means and show how it works in practice. I'm Brian, I make videos about civics and law. Tell me in the comments if you have ever heard of a summary judgment. And like, repost, follow me. You can also download a copy of the memo in support of the summary judgment from the LULAC case in my link tree. Okay, to explain summary judgment, I'm going to start by laying out a sample case. Okay, let's say we have a case called Smith v. City of Centerville, and Mr. Smith left his Christmas lights on all night that were allegedly blue, and Centerville has a law that no blue lights can be left on after 10 p.m. within the city limits. So those are our facts and our rule, but we're going to have two issues to resolve in this case. First, what color were these lights? Are they blue or are they green? And those are supposed to be lights. And second, Mr. Smith found an old law that temporarily redrew the city limits in 1798 right around his house. And even though it said temporarily, they never came back and redrew it. So he says the law doesn't apply to him. So these are our two issues. Now this right here is a question of fact. You use your senses, take a look at these, and decide if they're green or blue. This, on the other hand, is a question of law. You're going to need to look up what temporary means. You're going to need to see the original law, see if any other laws were written, see if maybe this was written for something that was happening for like 6 months or something like that. See if there's some reason this law was written. This requires a different kind of expertise to figure out the answer. So who decides each of these two questions? Well, believe it or not, the question is rooted in the separation of powers doctrine. See, we give Congress, and particularly the House of Representatives, so many powers because it most closely represents the people. And the people are supposed to run our government, right? Well, we do the same thing in the courtroom. We want the people to be represented in the courts, so they are represented by juries. Now, we recognize that this is going to be a tough question. All that research may be best handled by a lawyer. So we're going to give that question to a judge to answer. That's who answers questions of law. But there is no special training needed to look at something with your eyes and ears and say, is this blue or is this green? So we are going to take 12 random people off the street, our little temporary legislature, and ask them, is it blue? Is it green? You tell us. Questions of fact are answered by a jury. So this is how a basic court case operates. You have questions of fact, questions of law, they go to the jury, they go to the judge, and we get an answer to everything. Easy peasy. Now, let's change this up a little bit. Let's say Mr. Smith puts a little thought into this and decides he's probably going to lose with the jury here anyway. The lights probably are blue, and he thinks his other argument is way stronger anyway. So he doesn't want to waste time arguing about the color of these lights. So Mr. Smith concedes. He agrees that the lights are blue. So now, both sides of the case agree that the lights are blue. And this is what I'm talking about when I talk about facts in the legal sense of the word. Fact doesn't mean true necessarily in a court case. We don't care if these lights are blue or green anymore. They could be red for all we care. If both sides have agreed that for the purpose of this case, these lights are blue, then they are blue in this case, and that's all that matters. That is the facts of this case. It's something that we don't have to argue anymore, and it's a data point that we can use to kind of bounce the laws off of. The law says no blue lights, and these lights were blue. Okay, well, if we don't have a question of fact anymore, then we kind of don't need a jury, right? If they were only here to answer this one question and the other question goes to the judge, then the judge can take the facts that we've agreed on, which will be all written down on paper, and go sit in his or her office and decide the case without talking to Mr. Smith or the representatives of Centerville anymore. And we call that a summary judgment. It's a judgment where there's no genuine dispute over what we call a material question of fact. We may have a question about what kind of car Mr. Smith drives, but that's not material to our case. No material questions of fact exist anymore. And so the judge can make a determination all on his or her own in an office somewhere with everything written down on paper. Now, it's usually obviously not going to be this clear and simple. Usually one of the parties will make a motion for summary judgment, and they'll have to explain why we don't need a jury anymore. They're going to have to go through any potential questions of fact and explain why the question has already been answered with the stuff that we have in the papers. Like, for example, maybe we have a box that these Christmas lights came in and it says blue Christmas lights on it. Does that mean that they're necessarily blue? Maybe, maybe not, but that's going to be up to the judge to decide when someone makes a motion for summary judgment. The judge is going to look at that and be like, is this enough to decide for sure that these are blue lights and we no longer have to ask the jury? But if all of the questions in the case can be answered as a matter of law, then the judge can grant a motion for summary judgment. Okay, we got this much because the plaintiff in our LULAC case did something still a little bit different. So we're going to have to change this scenario even a little bit more to understand that one. Ready? Okay, let's add one more little twist. So it turns out that Mr. Smith may have been harassing a Centerville City government employee, and she has sued him for emotional distress. Now, the employee's case is actually a really big, complicated case with lots of questions, lots of accusations, a ton of questions to be answered. But one of the city government employee's accusations is that Mr. Smith, even after she asked him to stop bothering her, would come up with reasons that he had to come to the government office building and bother her, even though she told him to stop. And she has several different examples of times that happened. And this is all just one of those examples. She says he left the lights on purpose so he'd get a ticket and he'd have to come into the office to pay it. But he says he just left the lights on because the law didn't apply to him. So Mr. Smith is trying to narrow down this huge lawsuit a little bit. He wants to trim a few of these branches. And Mr. Smith is pretty sure he's going to win the 1789 part of the argument. So Mr. Smith agrees that the lights were blue. He concedes the factual question and he moves for a partial summary judgment. That means that the court will give a summary judgment on this one little branch of this big court case only. The rest of this case will go on as planned, but this question will be answered, and it will either disappear if he wins, or it will become a fact of the bigger case if she wins. So either the employee will have one less accusation, or it will become a fact that Mr. Smith violated this law. So in the LULAC case yesterday, the plaintiffs moved for a partial summary judgment, which means they presented a big memorandum explaining that all of the facts presented were all answered, and that the only questions left, at least on certain branches of the lawsuit, were questions of law. They want to close out some of the questions, and they think all of the information is there. There are no questions of fact for a jury to answer, and the judge should be able to answer some of these legal issues without any further information. So now the judge is going to look at the plaintiff's argument. It's like 58 pages long, and probably wait for the defendant to present their side of the argument and compare them and see who's right. And I'm just guessing here. In this case that I presented, this is probably more about strategy, trying to narrow the case down. My guess is that in the LULAC case, they are actually trying to move forward with some sort of a preliminary injunction that they can't do until they've closed off some parts of the case. By getting a final answer in some of the branches, they may have a stronger argument. That's just a guess. I have no idea what their lawyer strategies are, but that's probably a pretty good guess. Okay, so now you have another example of what facts and law are, what a summary judgment is, and what a partial summary judgment is. Hopefully this was about as clear as mud and you understand how all of this works. Also, keep an eye on this LULAC case. This is important stuff. You can get a copy of it from my link tree and take a look at it for yourself. I will be presenting more information on voting and democracy related law in the near future. I've been doing a lot of research on it. I just haven't pulled enough together to make a solid video script yet. But as usual, please engage with this video so people will watch it, comment, like, repost, get it out there, and keep watching. I'll keep making videos. Thanks a lot, everybody.